5 seconds to go. Start. Information exchanged during this meeting or any subsequent dispute resolution process, shall be regarded as without prejudice communications for the purpose of settlement negotiations and shall be treated as confidential by the parties and their representatives, unless otherwise required by law. However, evidence that is independently admissible or discoverable shall not be rendered inadmissible or non-discoverable by virtue of its use during the dispute resolution process, except the matter in controversy or dispute, all other terms and conditions of this agreement shall remain in full force and effect, pending the award of the arbitration proceedings. Subject to clauses above, all disputes are subject to jurisdiction of Delhi courts. This agreement shall be governed by and construed in accordance with the laws of India. Having noted the article, it is also necessary to refer to the judgments referred to by the parties. Learned Counsel has relied upon the judgment of the Supreme Court in the case of Wellington Associates Limited versus Kirit Mehta. In the said judgment, the Supreme Court was concerned with clauses 4 and 5 of the agreement therein, which read as it is hereby agreed that, if any dispute arises in connection with these presents, only courts in Bombay would have jurisdiction to try and determine the suit, and the parties here to submit themselves to the exclusive jurisdiction of the courts in Bombay. It is also agreed by and between the parties that any dispute or differences arising in connection with these presents may be referred to arbitration in pursuance of the Arbitration Act, 1940 by each party appointing one arbitrator and the arbitrators so appointed selecting an umpire. The venue of arbitration shall be at Bombay as such. The Supreme Court, while considering the aforesaid clauses, was concerned with the issue as to whether there is any binding arbitration clause. The Supreme Court, referring to a judgment of Rajasthan High Court in the case of B. Gopal Das versus Kota Straw Board, AIR 1971, held that the words quote start may be referred quote closed used in clause 5, read with clause 4, concludes that clause 5 is not a firm or mandatory arbitration clause as it postulates a fresh agreement between the parties that they will execute to go to arbitration. The judgment is distinguishable on facts, insofar as the judgment of the coordinate bench of this court in Panchsheel constructions as referred to by learned counsel is concerned, the court was concerned with the following stipulations in the agreement therein, quote start, that in case of any difference of opinion between the first party or owner and second party or builder in regard to the interpretation or scope of his agreement of any part thereof, they should try to solve the problem to any arbitrator. Quote close. The other clause in a collaboration agreement therein reads as under, quote start, that this transaction has taken place at New Delhi and as such Delhi courts shall have exclusive jurisdiction to entertain any dispute arising out or in any way touching or cornering this deed. Quote close, para. This court in Panchsheel constructions by referring to the judgment of the Supreme Court in the case of Wellington Associates Limited, has held that the said judgment squarely applies to the facts inasmuch as the usage of the words try to solve does not give a binding effect to the purported arbitration agreement between the parties. Stop. The court also distinguished the judgment of the Supreme Court in the case of Everest One Elevator Guide Rail Manufacture Company Limited, on which reliance was placed by the petitioner therein. Stop. Insofar as the judgment in the case of Quick Heal Technologies Limited, as relied upon by learned counsel, is concerned, the Bombay High Court was concerned with a dispute resolution clause, which reads as colon, all disputes under this agreement shall be amicably discussed for resolution by the designated personnel of each party, and if such disputes cannot be resolved within 30 days, the same may be referred to arbitration as stated below. Stop. Disputes under this agreement shall be referred to arbitration as per the Arbitration and Conciliation Act, 1996, as amended from time to time. Stop. The place of arbitration shall be at Pune and language shall be English. Stop. The arbitral tribunal shall comprise one arbitrator mutually appointed, failing which three arbitrators, one appointed by each of the parties and the third appointed by the two so appointed arbitrators. Stop. Para. Now, coming back to the question of minorities, you will please find why this particular resolution has been so widely put in that it might include a religious minority as well, a linguistic minority as well, or an economic minority, as some honorable members rightly pointed out. Stop. Para. Now, sir, a question arises whether there ought to be any such protection insofar as a particular type of minority is concerned. Stop. I shall deal with the question of minorities at some length. Stop. But you will please find, sir, what the honorable mover wants is that there ought to be a permanent minorities commission. Stop. It ought to be endowed with statutory powers. Stop. Therefore, sir, an attempt is being made for the first time by my honorable friend for driving a wedge between a community and a community. Stop. Para. So far as the constitution is concerned, as my honorable friend rightly pointed out, whenever the question of minorities arises, we have to be extremely careful. Stop. The constitution is a very sacred document which has embodied all the different aspects of the common question of India's nationality. Stop. India is one in spite of different types of languages and religions. Stop. But in the midst of all these diversities, we have to develop a common nationality. Stop. Therefore, whenever we consider the question of the development of the nation and the interest of the nation, you cannot afford to think in terms either of religion or of language. Stop. Para. It is true, sir, that there are different religions. Stop. It is also true that there are different languages. Stop. Therefore, a question arose and the framers of the constitution had to devise a constitution in the midst of the unity of India with certain diversities here and there. Stop. For that purpose, what they did was, they devised a common nationality for the whole of India, and insofar as religious minorities were concerned, they were given certain rights. Stop. I would not go into the details regarding the provisions of the fundamental rights regarding the practice of religion. Stop. Certain rights have been given to the religious minorities, and beyond that, it would not be proper to bring in the religious minorities for political rights. Stop. For that, we have to be extremely careful. Stop. I would also point out that while we have to develop a common nationality, the members of the Indian nation have to understand that we are one nation. Stop.